And we're live.
All right. Good morning. It is February 7th, Friday, and this is Senate Health and Welfare. This morning, we're going to look at S28 and have a walkthrough with Ledge Council. S28 is an act relating to access to certain legally protected healthcare services. We'll do that. And then we have some time perhaps here for folks who are in the room. Then after that, we have some really important information from a young person who had a cardiac event at Milton High School. Survivor story, pretty compelling. And from the Pharmacists Association. So terrifically full day, but enough work to keep us busy. So Senator Hardy, welcome. Please introduce yourself for the record and then help us understand what the bill does, sort of kind of the umbrella and the importance.
Yeah, absolutely. Thank you, Madam Chair, and thank you for having me in Senate Health and Welfare. I'm Senator Ruth Hardy from the Addison District, and I'm here to just give you a brief overview of S28. This is a bill, as the chair said, that updates some work that we did here in this room and in the legislature 2 years ago related to legally protected healthcare and the legal and constitutional protections for healthcare. And this language in it in S28 updates some of the provisions related to clarity and truth and advertising, so to speak, on healthcare to make sure that patients have the information that they need. And also it updates some of the professional responsibility requirements for healthcare providers. And one of the reasons that the bill is a little bit lengthy is because, as Jen will explain, it repeats the same language across several professions. So physicians and advanced practice nurse practitioners and physician assistants. And so it's the same language being repeated multiple times. And it's just about making sure that they are taking responsibility for the healthcare that they're providing, and also that the people who report to them under their license, that they are taking responsibility for the healthcare that they provide as well. So that's why the bill's a little bit lengthier. And it's really just a bill to make sure that Vermonters get the information they need from their healthcare providers, and that there's clarity in oversight and information provided.
Thank you. Good. Yeah, I know it does relate to reproductive health care very directly, and that's important based on the work that we've done in the past.
Absolutely.
Actually, question for Senator Hardy. Thank you for your work on this, and everyone's long and hard on it.
You're welcome. Thank you for taking it up. It's an important bill to make sure we protect Vermonters and the healthcare they receive.
Thank you.
Thanks. I'm going to talk about salt.
Oh, I know.
A lot of it. We're using a lot of it. Too much. It's making our water sad.
I'm feeling a little salty, so
That's good.
Yeah.
Have
Fun, everyone.
Not to be called an old salt. Okay. Okay.
Good morning. Jen Carty from the Office of Legislative Counsel, and we are looking at S28. So you got a good overview from Senator Hardy. And we'll put this up on the screen and take you through it. Right. So S28, as you heard, is an act relating to access to certain legally protected healthcare services. It starts out in Title IX in the Consumer Protection Act, and it expands some provisions that were originally enacted in a more limited fashion, applying to pregnancy services centers, and this expands that to apply to all healthcare services. It revises some findings and legislative intent that again were more focused on pregnancy services centers. And it has it keeps two of the findings from the existing statute. So it would have the General Assembly specifically still finding that telling the truth is how trained healthcare providers demonstrate respect for patients, foster trust, promote self-determination, and cultivate an environment where best practices in shared decision-making can flourish. Without veracity in information and communication, it is difficult for individuals to make informed, voluntary choices that are essential to one's sense of personal agency and autonomy. My recollection, for those who were on the committee when this was worked on, was that some of the language in these findings came from the Vermont Ethics Network, kind of about how patients and providers work together. And it also retains advising strategies and educational information about healthcare options that lack transparency, use misleading or ambiguous terminology, misrepresent or obfuscate services provided, or provide factually inaccurate information are a form of manipulation that disrespects individuals, undermines trust, broadens health disparity, and can result in patient harm. So it'll be a much shorter first section in that subchapter. Similarly, section 98-2492 goes from a long list of definitions to just a single definition that is focused specifically on the definition of healthcare services. And this is largely a definition that is used elsewhere in statute, although I think we've been sort of refining it over time. So healthcare services means services for the diagnosis, prevention, treatment, cure, or relief of a physical, dental, behavioral, or mental health condition or substance use disorder, including counseling, procedures, products, devices, and medications. And then in section 2493, which is the kind of the main reason this subchapter is in the Consumer Protection Act, is focused on unfair and deceptive acts in commerce, which is what the Consumer Protection Act is. And this makes it an unfair and deceptive act of practice in commerce and a violation of section 2453 of this title, which is kind of the heart of the Consumer Protection Act. And then it expands the scope from any limited service pregnancy center to any person to disseminate or cause to be disseminated to the public any advertising about healthcare services or proposed healthcare services performed, and again, more broadly in this state, that is untrue or clearly designed to mislead the public about the nature of the services provided. And then it maintains language around advertising, including representations made directly to consumers, marketing practices, communication in any print medium, such as newspapers, magazines, mailers, and handouts, and any broadcast medium, such as television or radio, telephone marketing, or advertising over the, and just move to not capitalizing the word internet anymore, so a lowercase internet, such as through websites. And the existing language says web ads. I prefer advertisements for in statute. So web advertisements, and then this would add social media. For purposes of this chapter, advertising, and then it takes out the reference to provision of services by a limited services pregnancy center. So advertising about healthcare services is an act in commerce. And then as Senator Hardy was mentioning, it takes out language that was in this provision or is currently in this provision related to healthcare providers who are providing services or involved in providing services at a limited services pregnancy center and their responsibilities. Takes that language out of here, but puts in some more responsibility language or expands on some existing language in the healthcare professional statutes. So we will see those in the coming pages. And then it keeps the authority for the Attorney General to make rules, conduct civil investigations, and bring civil actions. These are the standard authority they have under the Consumer Protection Act. And it takes out the reference to subsection A because we're just down to A. Or A and C. All right, section 2 is a little bit of a different topic. And we're just going numerically in order of the statutes in the, or of the titles of the VSA. So we went from Title 9, now we're in Title 18. This is on some reporting about fetal deaths. There are existing provisions requiring certain fetal deaths to be reported by the hospital physician or funeral director to the Commissioner of Health within 7 days. And so on forms provided by the department. And so this is just some cleanup language around the structure of the provision, because what is currently subdivision A3 really doesn't fit as A3. It should be A2 with the ones above it as A1 and A and B. Inside baseball there on drafting. And then some change to a non-gendered term on line 18 on page 8. And then the biggest change here is on page 9 in subsection D, and that is specifying that those fetal death reports are for statistical purposes under existing law, for statistical purposes only, and are not public records. But this specifies that they shall be kept confidential as well as being destroyed after 5 years. The fact that they're not public records may imply that, but this makes it more explicit. Starting in section 3, we get to the various professional licensing statutes that Senator Hardy was talking about. The first group here in section 3 is those professions regulated by the Board of Medical Practice. And we're looking specifically at the unprofessional conduct statutes. So first I've added in some subsection headings. So on line 10 after A, where it says prohibited conduct, that's just a way to describe what's in this long subsection. You'll see when we get to the bottom, subsection D was added with subsection heading, and we try to be consistent. So I'm just adding that in A. And this is but it is the list of prohibited conduct, what constitutes unprofessional conduct. So in existing subdivision A2, currently it is unprofessional conduct, all advertising of medical business. This adds healthcare services or a medical business that is intended or has a tendency to, and this adds confuse, mislead to the existing deceive.
There's a little period in there that doesn't belong after the comma, after mislead. Or is that just?
That's a comma.
No, there's a comma after mislead, then it's
Not on here, there isn't.
okay.
It shouldn't be.
Must have been a little ink thing.
Yeah, okay. Otherwise, if there's an extra period in here.
I'm not an editor, so.
Well, no, if there's an extra dot in there, luckily it doesn't seem to appear in this version.
If it's up there, it's a comma.
It's a comma, but I think hers has an extra period and a comma.
dot.
Extra dot of some sort with the comma. What's yours?
Comma.
All right. No, I think it's literally that sheet of paper then. All right. So this is again adding healthcare services in addition to medical business around the advertising, and adding confuse or mislead to deceive. In existing law, prohibited conduct is permitting one's name or license to be used by a person, group, or corporation when not actually in charge of or responsible for, in the existing languages, the treatment given. So this expands that to say the treatment or other healthcare services provided. On page 10, this goes into some additional pieces about using the licensee's name or license. So this would be new language. Failing to provide active oversight over treatment or other healthcare services that are provided using or relying upon the licensee's name or license. Failing to actively monitor the education, training, and experience of individuals providing treatment or other healthcare services that are provided, again, using or relying upon the licensee's name or license. Or failing to review and approve information about treatment or healthcare services that are provided using or relying upon the licensee's name or license prior to communication of the information to users or potential users of the treatment or services. So I'm putting some more oversight responsibilities or more specificity on the oversight responsibilities of somebody who's allowing their name and license to be relied upon. Delegation of, this is an existing provision, delegation of professional responsibilities. This would specify and including delivery of any healthcare services to a person whom the licensed professional knows or has reason to know is not qualified to perform them. And then in subdivision 33, there's an existing prohibition on providing, prescribing, dispensing, or furnishing medical services or prescription medication or prescription-only devices to a person in response to any communication transmitted or received by computer or other electronic means when the licensee fails to take certain actions to establish and maintain a proper physician-patient relationship. And so this is all existing law, but there is an existing carve out that says for purposes of this subdivision 33, an electronic, online, or telephonic evaluation by questionnaire is inadequate, not the carve out yet, for the initial evaluation of a patient. And then we create a carve out except as otherwise provided in subdivision C4 of this subdivision 33. And then the existing law, again, here's where the existing carve outs are, says the following things are not a violation of this prohibition on sort of doing things electronically. Initial admission orders for newly hospitalized patients, prescribing for a patient of another physician for whom the prescriber has taken the call, prescribing for a patient examined by an advanced practitioner supported by the physician. And then this would add a new provision that references the reproductive rights chapter. So in furtherance of the reproductive rights chapter that prohibits interfering with a patient's access to reproductive services, prescribing medication for an individual to terminate the individual's pregnancy based on an adaptive questionnaire that allows the licensee to obtain additional medical history and ask follow-up questions as needed. So that would be a new exception to that broader prohibition. And then just renumbering the remaining provisions. Then in another part of the Board of Medical Practice statutes on failure to practice this is just adding the subsection heading failure to practice competently under the existing provisions around failure to practice competently. Same thing with subsection C, adding the subsection heading burden of proof. And then you can see there was that subsection heading already in existing law for subsection D. And we are dividing, so leaving D, what's in there right now as D1 as just D, and then using some larger subdivisions. And then we get to the definitions, and this is adding as its own subsection definitions of healthcare provider and healthcare services as instead of having them lumped in. Some of this is just drafting mechanics. But because these definitions in part are now applying to the whole section as opposed to just to the subsection, that's why I pulled them out as their own subsection. And then added the word counseling under healthcare services as part of that broader definition. So this is the most involved one, this Board of Medical Practice section. The rest of them are less extensive. Section 4 makes some amendments to a section on unprofessional conduct in the nursing professions. And so this is adding some language like we just saw in the previous section. Say
All right, okay. So we're back. Excuse me, this is Senate Health and Welfare. We had a little technical interruption and now we'll continue. So Jen, okay, it's still going on.
Yes.
There you go. Start over. Page, I think we're on page 14.
Just have to get back. Back. All right, yes, bottom of page 14. We're adding in a consistent definition of health services. Health care services, now that I'm really looking at it closely. Just make a note of that. Section 5 is specific to advanced practice registered nurses. So the subset of nurses who have additional training and licensure and a broader scope of practice. They have their own additional unprofessional conduct statutes. And in theirs, they have that same language or similar language around prescribing pursuant to electronic communication. And so I have created a similar carve out here. This is structured a little bit differently than the one in the Board of Medical Practice. So you're not looking at 33A and B and all of that. It's the exceptions are in subsection B. But otherwise the language is basically the same. So we'll revisit subsection B when we get there in a moment. But first we have this language around permitting one's name or license to be used by a person, group, or corporation when not actually in charge of or responsible for the treatment and changing given for other healthcare services provided, and using that same language around failing to provide active oversight, failing to actively monitor, and failing to review and approve information. And then we have subsection B, where it had said except as otherwise provided in subsection B. And now subsection B says except as otherwise provided in subdivision 2D. And this is using, again, similar language to what we had in the Board of Medical Practice statute in furtherance of that 18 VSA chapter 223, prescribing medication for an individual to terminate their pregnancy based on an adaptive questionnaire that allows the licensee to obtain additional medical history and ask follow-up questions as needed. Here also we have health services. I have to look at maybe that the term health services was already used in the chapter, and I was just being consistent with that terminology. Section 6.
Wait, say that again.
Oh, I did the use of the whether now we're in the statutes on physician assistants, and there are fewer provisions in their statutes around unprofessional conduct because their scope of practice is smaller than that of a physician, so they're not generally supervising other providers, for example. But there's language in their statute that talks about occupational advertising. So we've added for advertising about healthcare services that is intended or has a tendency to, and again, adding confuse and mislead along with deceive. And then I've been using health services laws. So we have to look at that. But health services here means that has that same definition. Section 7 is the unprofessional conduct statute for osteopathic physicians. The Board of Medical Practice, for those who have not been through this before, Board of Medical Practice regulates, among others, allopathic physicians, which is what you typically know as MDs. The Office of Professional Regulation regulates osteopathic physicians who have almost identical training and scope, or very similar training and almost identical scope of practice, but they are regulated by a different entity in the state. So a person who is licensed, and I put as an osteopathic physician in here, even though it's in their chapter, just so it's clear what we're talking about. And their unprofessional conduct statutes include delegating professional responsibilities, and I've added including the delivery of healthcare services like we did for the MDs, and just for medical correction. And then adding new language for them, but that was consistent with what we had for other professions, permitting one's name or license to be used by a person, group, or corporation when not actually in charge of or responsible for the treatment or other healthcare services provided. And then that same language around failing to provide active oversight, failing to actively monitor, and failing to review and approve information, definition of services. Now we jump briefly to another topic in here just because of the numerical order of the statutes, and it has to do with the pharmacy, profession of pharmacy, and the board of pharmacy. And this is a provision around confidentiality of prescriber information on medications for legally protected healthcare activity. And legally protected healthcare activity is the umbrella term used in Title I for reproductive healthcare services and gender affirming healthcare services. And then those terms are also used in this section so that these definitions refer back to that same section in Title I that also defines legally protected healthcare activity. And then the meat of this is that upon request of a prescribing practitioner, and to the extent not expressly prohibited under federal law, a pharmacist shall not list the practitioner's name on a fulfilled prescription for medication for gender affirming healthcare services or reproductive healthcare services, but shall instead list the name of the facility at which the practitioner is employed or is a contract employee. So this allows a healthcare provider who's prescribing medication for gender affirming care or reproductive care to ask that their specific individual name not be put on prescription, prescription bottle or container. And then it also specifies that nothing in this chapter or rules governing the pharmacy profession shall be construed to require a pharmacist to list the prescribing practitioner's name on this fulfilled prescription for those types of medications. So C is just some protection for the pharmacist who is complying with what B says is allowed. Lastly, we have the unprofessional conduct statute for naturopathic physicians, and we've added, oh, thank you. I left it in. Send a shout out, not too delegating professional responsibilities, including the delivery of healthcare services to a person whom the licensee knows or has reason to know is not qualified by training, experience, or licensure to perform them. So this is a provision that appears in many of the other professions, healthcare professions, but is not currently in the naturopathic physician statute. So this is consistent as language that is consistent there. Also adds consistent language around permitting your name, person's name or license to be used by a person, group, or corporation when not actually in charge of or responsible for the treatment or other healthcare services provided. And then those same provisions around failing to provide active oversight, failing to actively monitor, and failing to review and approve information. And the definition of health services, which I think you've only called health services. And then this act take effect on passage. There you go. So as Senator Hardy said, there's a lot of repetition in those healthcare professional statutes,
Right.
but the idea is to align them and have consistency.
So it's adding, it's really updating, I think, all of the relative sections of statutes based on profession. Okay. Questions for Jen on this? Okay. All right, I know this is our first walkthrough, and I'm thinking that because it does improve statute quite a bit from what we had, it might be helpful for us to work on it sooner than later. And I know there are people in the room who would like to comment on the bill. If you're not ready to do that, we can just have you connect with Kiki and we'll put some testimony in fairly soon on the bill. Anything else on this one? I mean, it's a lot because, and especially for Senator Douglas and Senator Hart, who haven't been in the room with us while we've been working on this for the past couple of sessions. But I think it's an important set of updates that it actually really improves the language. Thank you for doing that, Jen. Okay. Wow. How could we do this? Any comments or questions, committee, on this one? Good?
I had one for you.
Sure.
On page 7, where it says the provision of services by a limited services pregnancy center. Is that like taking some of the services away from pregnancy center, or what's that doing? That's Bill.
Probably a question for me.
Yeah,
So I'm sorry, and can you repeat your question?
Yes.
it is a question for John, please. Yeah.
On
But
page
where are you?
7, after it says for purposes of this chapter, advertising of the provision of services by a limited service pregnancy center.
Yeah, so that is not taking away any of their ability to do anything. It is broadening the provision that says for purposes of this chapter, advertising. And it's taking it out of just the scope of limited service pregnancy centers and applying it to healthcare services broadly is an act of commerce. It doesn't change what type of services they
Okay.
can provide or.
When I saw the line through it.
Yes, yes, and you'll see that in a lot in here because we are expanding the scope, so, but that's not.
Okay, so
I'm not
answer my
undoing
question.
that.
Thank you.
Good question. Any other questions? All right, well, so as I said, we'll put people on the agenda for this one and take testimony, and it might, we might be able to get this one out sometime next week if we do that. Unless there's questions, because I think it really does help expand all of the ethical guidelines, really, but important guidelines for commerce within the healthcare profession. That's okay.
Yeah, I have a question for you.
Yeah.
Alright,
All throughout your report, themes, can you define confused, because that feels a little broad to me. And what might be confusing to one person might not be confusing to another person. So who set the determination of what is confusing? I think that word mislead, I think that is very similar to deceive, and that could be pretty set in stone of what is misleading. It's blind, but confused is a very subjective term, and it's not very objective. So.
Yeah, I think in general, with a lot of things in law, it's using the reasonable person standard. So if a court were to, if somebody were to be, disciplined and on the basis of doing something that was deemed confusing, it would be first the regulatory board, and then ultimately, if they were to challenge it, the court determining whether a reasonable person would be confused by, would be unable to determine what was going on from the information provided. We can certainly talk about whether that's appropriate, whether that's the word you want to include, or whether the committee wants to make a change. It's an interesting question. I want to look at case law and see if there's guidance on it.
I don't like subjectivity in law, and I rather like things set in stone rather than going off of the courses in many instances as much as you can.
Yep, no, it's a good thought.
Okay, that's a good question. And so while we're looking at this and hearing testimony, maybe you could help us with the case law piece.
Yes.
Great. Anything else like that? Any other wordsmith? We will do wordsmithing as we go through and we hear from people. So that's why we do this. Very important.
Representations made directly to consumers, does that mean mouth to mouth? Two basic things.
Can you show me?
It's in section 2004-93, right in front. Well, not right in front, but a couple of pages. This advertising includes representation made directly to consumers. Is that like face to face, or like giving somebody a handout, or what page?
Yeah, I think anything that is,
Six.
I think direct to consumer is maybe more of an established term, but no, I don't think it means directly mouth to mouth. I mean, I think it can include that, but it can also include, as opposed to information provided through through an appointment with your provider. This is reaching out to individuals as consumers. So, radio, media, yes, direct face to face as well.
Where is that?
It is at the bottom of page 6, top of page 7. It's existing law.
Ah, okay, got it. Oh, it's existing home.
Yes.
Well, not, yeah.
And the Attorney General's consumer protection folks may be able to shed some light on that, because I think that language is used in in existing statutes, in other existing statutes in their purview.
I asked Jen one more question.
So yes.
Yeah, no, go ahead.
In here it says the board, who's the board?
Depends where you are.
The board
Depends
of
which
that
section.
hospital?
No, it depends what, it's usually the regulatory board. So depending on what section you're looking at, it could be a board of a particular profession in the Office of Professional Regulation or a board of medical practice if it's one of the professions they regulate.
So, yeah, so for example, if you,
Right, the licensing board.
yeah,
Licensing. Oh, so it's a licensing.
yeah, the licensing.
Yes.
Yeah, because it just says board, it doesn't.
Right, because it's in context
It's
in the
referring to
statute.
section.
Right, so in context in the statutes, it's clear which board, but sometimes out of context, it can be less.
That's fine. Thank you for answering.
One of the confusing things we learn about is how people are regulated where. And so Office of Professional Regulation has a whole host of professions, including nurses and DOs, doctors of osteopathy. And then the Board of Medical Practice has PAs, podiatrists,
Yeah.
and MDs.
And a few others, radiologist assistants,
Yeah, radiologists.
anesthesiologist assistants, I believe.
So that when you go to the different sections of different titles and different sections of law, talk about APRNs, oh, you're in the Secretary of State's office. But you just want to forward.
All right.
One more, keep going. You have another question?
I might have a couple more.
Yeah, no, please do that. This is the
On
time.
page 6 again,
Okay.
on the same section. It says, violation, what penalties are there for that violation, or for that section?
So there's-
Civil penalties, is it?
They are, I believe they're civil. It's, this is all in the Consumer Protection Act. So there's a lot in that one and I don't spend as much time in that one as I do in a lot of our healthcare ones, so I have to look. Consumer Protection. But I think the general, and there's antitrust falls under here as well. There's civil investigation, civil. Any person who violates, well, the terms of an injunction, which is often what's happened is somebody's told to stop what they're doing. So violation of the terms of an injunction is a civil penalty of not more than $10,000 for each violation. But it's the court that is issuing the injunction. There is for a consumer who contracts for goods or services in reliance upon false or fraudulent representations or practices, or sustains damages or injury as a result of any false or fraudulent representations or practices. These are ones that are specifically prohibited. May sue for appropriate equitable relief and may sue and recover from the seller, solicitor, or other. So there's a private right of action. The amount of their damages or the consideration or value of basically get their money back, reasonable attorney's fees. They can get punitive damages, exemplary damages, not exceeding 3 times the value of what they paid. So there's a lot in here. I would want, I'd probably defer to the Office of the Attorney General to tell you how this plays out in practice, because they're the ones who enforce the Consumer Protection Act. This is what I'm finding by looking briefly in statute. And then some sections, I believe, have their own penalties for violations.
Maybe you could talk to that a lot of this is currently under consumer protection. We're adding we're improving the language that's currently there.
Right, there is language in existing.
Not changing.
Right,
consumer
that is
protection.
existing, right, that is existing law in 2493, other than the changes we are making around important. Broadening the scope. And I'm curious now to look. So let's see if I saw the word confused on the quick word search of the chapter, which I have. Oh, it may be. Yes, sir.
Well, I was chair last year of this committee. I know there was some concerns about the limited pregnancy centers and advertising.
Yeah,
But this would also pick up, last time I was here, they were taking your blood and centrifuging it and putting it back in.
Stem cell, we have,
Stem
yes,
cell,
we have a
yeah.
separate statute on stem cells. Yes, I
Yeah,
mean, there
but
is, I would
that's
say
that,
there is
like
a
that,
overlap.
that
Yep.
kind of advertising. Somebody lost their eyesight, right?
yes, exactly. Yeah, we
Having it re-injected in your eyeballs.
Yeah.
So we were after that.
right.
I
So
know,
when you
and
get,
you have a doctor's name up there. But
Right.
he wasn't here when they rented a storefront and
did it.
started centrifuging your blood, yeah.
Thank you for reminding us. That was a big lift and it was also received national attention. That though was good. Yeah, so,
Notice and disclosure requirements around unapproved, non-FDA approved stem cell.
Right.
And stem cell related products.
okay. Any other questions? Oh, I think it is, it's helpful. The questions you're asking, Senator Douglas are helpful in that it helps us understand what's here in terms of consumer protection. Our role is to ensure that we have, medical policy in place that is comprehensive. And I think this helps to do that.
Just listening. Are we adding any restrictions or are we, it sounds like we're basically cleaning up the statute and clarifying it.
I mean, I think we are, this would expand the scope of the providers who would potentially be, I mean, from a practical standpoint, probably not changing it much, although you'd want to hear from the licensing boards. But I think it does give the Office of the Attorney General some additional authority over a broader set of providers or non-providers, you know, individuals who are not licensed who might be
Like
disseminating
the storefront
misleading information.
cell therapy that you were talking about,
Yes, okay.
not licensed.
Right, well, the individual, I'm thinking the individual provider.
Right.
So if you have somebody who is, aside from, you know, if somebody is doing something that is specifically within the scope of practice of a provider and practicing without a license, then there is, you know, there is the ability to go after them for unauthorized practice of a profession. But sometimes there are things that are not necessarily only for those who are licensed professionals, but may still be providing misleading information. And so this allows the Attorney General to have a role in the Consumer Protection Act and protecting consumers from
Misleading information.
misleading
That's a
information.
really good phrase. All right, any other questions?
How would this pertain to statements that are made by doctors or really made by anybody about certain treatments or procedures that aren't 100% effective? Because I see like when you have not every medication is going to solve an issue 100% of the time. So if it's only 50% effective, how can you say that this will cure your ailment? Or
Defer to the licensing boards on that.
Yeah, that's a good question for Board of Medical Practice, the Board of Nursing. We'll bring OPR in.
As the pharmaceutical companies do it every night.
They do it every night, 15 different commercials every other second.
And then they give you the side effects at the end.
Right.
So why would anyone ever take it?
I like the one that says this may result in death.
Yeah.
Whoa.
I think it's more than one of them.
Okay, no, I don't like that.
But ask your doctor about it,
Oh.
if it might be right for you.
Any other questions for Jen? I thought you're getting to the place where, you know, when we take testimony, it'll be good to ask some of these questions and the value of what we're doing here. We set? Gonna go once?
I've got 1,000 more, but we can.
No, just go, keep going.
Well, I just
We'll
have-
take a few more.
I just have general concerns about, it's very, very broad is what I'm seeing here. Again, on page 6, that whole, unfair and deceptive action. Rather, if there's intent, knowledgeable and willing intent, the people providing these advertisements or representations. If somebody gives information that they believe is true, but turns out it's not. Or like, if everybody else knows it's not true, but they think it is, I just don't see any intent here. When it comes to other spots here, other areas of the Consumer Protection Act and in commerce generally, like look at financial services. If you provide information to somebody, and they go out and they buy stocks in a company because you suggested it, and then they lose all their money, you've caused them harm. But did you do that intentionally or not? Because if you gave them information you thought was good, but it ended up not being, and everybody else knew it wasn't going to be good, but you thought it was, then it's unintentional. And generally laws include that line of with intent. So I'm pretty concerned that there is no intent factor to this. And I also have some concerns of First Amendment constitutionality. Just because it gets rid of limited service pregnancy centers, replace it with any person. And it doesn't cover, takes away the very specific narrow focus of what the law is trying to do for people that are either licensed or operating in a fixed capacity of a particular facility or business, and just makes it person. And I think that's extremely broad, and I do worry about constitutionality issues with this. That's my biggest issue with the bill, though. When we were going through it, another thought did pop into my head with the all the different sections here. And this is coming from what I do in my day job. We have APRNs or doctors that license our facility and lend their license, and then we give medication to clients based off of their license. And a lot of this stuff here, and again, I'm not an expert on this section of the law, so I can't, maybe it's already covered elsewhere, but failing to provide active oversight, failing to review and approve information about treatment healthcare services. Often we will describe the client over the phone to the doctor or the person whose license covers our facility. They'll never even meet the client. So, how can they have active oversight over treatment and other healthcare services when they never step foot in the building? So I worry that this might put people that are doctors or prescribers or APRNs that are in very similar situations in kind of a weird legal quagmire of how can they actively use their license and allow us as mental health workers or any other workers on the ground in my similar situation to do our jobs, but without unintentionally violating provisions in this law that we're putting down and hurting the person whose license covers our facility. I worry about that as well, and whether or not we're going to have unintentional consequences for healthcare professionals.
That's a good question.
That's a good question, and if every time we go through things like this, those kinds of questions come up. So we will hear from the boards, and we'll hear from practitioners, and know that there's always that gray area of concern, and that we are not the Consumer Protection Committee, but we are the Medical Practice Committee, and so we want to focus on that and what we can support for medical practice.
So you know what is actually happening with you,
Yeah,
because
Yeah.
we got 5 senators that drafted a bill. I don't know that any of them know what's actually happening.
Yeah. And then also, I don't need to give you the section, but failing to actively monitor the education, training, and experience of individuals providing treatment or other healthcare services. Again, these people never step foot in the building. How can they actively monitor our experience? It's because right now we're having a lot of issues, as I'm sure every single person in the room here knows. We have troubles hiring people in the healthcare field. We don't always hire people that have requisite experience. So I also, again, weird legal quagmires that I don't want to put healthcare professionals into. So.
There is a lot of that language that will not to remember. That's okay. And that has stood well. So we remember there's some stuff in here that we want to make sure that our practitioners are telling the truth and are working honestly from a professional scope of practice. That
Of course.
yeah, so.
You could ask.
Yeah.
Ask them.
Yeah.
I'll be quiet now. If it'll.
No, don't be quiet. This is helpful. Thank you, Senator. It's very good. And it helps enrich the discussion and then to focus ourselves on what exactly we are doing here. You know, we're not changing the consumer protection law, but we are ensuring that whatever our medical practitioners are doing is ethical and is within their scope. So that's really it. So, okay. Any other questions? We're going to have good conversations in here. I can see that. Any other questions? All right, we're good. So, you folks who are here, we're gonna take a break right now, and obviously we've got some time. What I'd like to do is for us, thank you, Jen, very much for that. Appreciate it. And I'm going to put together some folks who will testify for us on the bill. So obviously the boards of practice and then practitioners. And I see practitioners in the room, so we're going to have you folks up. And Kiki can set up our agenda together. And then, and we'll do that I think we have time next week. Don't we keep you?
Yeah.
Yeah, okay, we can do that.
Yeah, and the question that kept coming up in my mind is what problem are we trying to fix?
Right.
So that would be
Yeah,
helpful to
Yeah.
know.
well, I
I
think what we're,
think I know. but
yeah,
I
no,
think
it's trying
it'd be
to
helpful
move
know.
it from specificity to broadly, we can't just identify one
Right,
type of one organization. We want to move it to all medical practitioners because it makes more sense that way.
right.
And then, so what I would like for us to do right now is to take a break until 10:30. And actually, if you're a little bit later than that, 10:35, that would be fine. And Kiki will go off